Hello, everyone. Welcome. Thank you for joining us today. My name is Katerina Honcharenko. I'm an arbitration professional practice manager at the Chartered Institute of Arbitrators, and today I will moderate the discussion. We are here to continue our series of 12 events dedicated to the use of AI in alternative dispute resolution titled AI and ADR Theory in Practice. We would like to thank TrialView and Yusmundi for partnering with us on this series. And I encourage everyone to attend and explore this complex and interesting topic with us. I will now mention a couple of housekeeping points. This event is being recorded, and of course, the recording will be made available to everyone who registered. In terms of the format, we will have a panel discussion first, which will take approximately 50 to 60 minutes, and then we will have some time for Q&A. Also, please note there are two engagement tools available for you: the chat function that you can use for general discussions and raise any technical problems, and the Q&A function. If you have any questions, please leave them in the Q&A box at the bottom of your screen so they don't get lost and you can see them. And if you see a question posted by someone else which you support, you can bring this to our attention by upvoting their comment. And if your question is directed at a particular speaker, we ask you to please make this clear. Our speakers today are Alexandra Wagenheim, a VP of Global Legal Data at Yusmundi, Amar Makan, Commercial Director at TrialView, Kiran Nasir Gore, an arbitrator, dispute resolution consultant and counsel in Washington, D.C., Professor Maxi Schrerer, a special counsel at Wilmer Hale and Dorr LLP in London, and a professor of law at Queen Mary University of London. And last but not least, William Dunning, supervising associate in Simmons & Simmons Dispute and Investigation Team in London. Now we can move to the substantive part of our event. During today's webinar, we will focus on regulation of AI and relevant mechanisms available internationally, and in particular focus on the European Union's AI Act, the first international regulation on AI available today. I suggest we start with a general discussion and see what does regulation of artificial intelligence imply. I would like to set the scene a little bit here by making the following reference. In one of his interviews in 2023, Sam Altman, the CEO of OpenAI, a research organization that in particular developed ChatGPT and Sora, said, "There are soon going to be a lot of capable OpenAI LLMs," he meant large language models, "with very few to no safety controls on them. And so you can try with regulatory approaches, you can try with more powerful AIs to detect this stuff happening. I'd like us to start trying a lot of things very soon." In 2024, Sam also mentioned with regard to regulation and emphasized his preference for international agency being responsible for monitoring AI, that, quote, "I'd be super nervous about regulatory overreach here." He also said, "The reason I've pushed for an agency-based approach for kind of like the big picture stuff and not like a write it in law is in 12 months it will all be written wrong." End of quote. And realizing the scale of the matter, it's not hard to imagine. So I have a couple of interrelated questions here. In your opinion, how do we keep up with the rapidly evolving industry? How can the law keep up? And how to handle the growing willingness of some companies or institutions to self-regulate? Please, Amar, William, Alexander, or whoever wants to start, please feel free to do so.
Yeah, I'm happy to start. Thanks, Katerina. Yeah, so really, this is quite a big question to open with, and I imagine that the theme today is really going to be one of tension, that tension between, for example, innovation and regulation. And there was a recent report, I think it was Thomson Reuters recently published their report on what the kind of appetite was for very stringent regulation, or whether lawyers wanted to self-regulate. And it seems as though the approach in the UK and the US, for example, and I know we will be looking really closely at the EU approach later, but the approach in the UK and the US so far seems to be, this is on the basis of that report, but also on anecdotal discussions, that because AI is evolving so rapidly, that the appetite to self-regulate seems to be growing, rather than actually putting in place measures now, when in fact the technology will have evolved so much in 6 months' time, in 12 months' time. Who knows where we'll be in 5 years' time. And I think it's really interesting because, having looked through, and I haven't read it in detail, but having looked through the EU Act, there is so much emphasis on innovation, and there is nothing to say that, innovation and progress can't run in alignment with the regulation. So I think that if we put the foundations in place first, which is obviously the purpose of this kind of legislation, I think it's very interesting that the EU has the approach that they've always taken, which is, it's about standardization, it's about harmonization, and obviously they're looking at the internal market, etc. But I think they've really said these are the cornerstones. There's a lot of talk about sandboxes for AI, so that that you can still develop and innovate in a controlled manner. And we are obviously all very much in this transitional phase where there's a lot of ambivalence, there's a lot of excitement, there's a lot of fear. And I think that, this kind of paradox is going to be a very interesting one to navigate, but I don't see why we can't run them both in sync. Having worked in practice, I understand that, law is founded on security, on confidentiality, and it's all about, ensuring that that is paramount and that everything is regulated. And now working on the tech side, obviously I see how important it is to have some freedom and flexibility to innovate. Otherwise your product and your company isn't competitive as the next. So yes, just my initial thoughts really.
If I could pick up from there, Emer, I think you implied some really great concepts in the tail end of your comments about practitioners. And I think our audience primarily, you might have some tech innovators here, but primarily we're lawyers or aspiring lawyers. And there is a distinction between regulation of use, which for international lawyers in particular, will vary depending on jurisdictions. And it's not that different from the debate that we've had for many years about ethics and international practice. Differing standards can change the playing field for differing players. But I might just add on top of that there's also a distinction between regulation of use and disclosure of use. And I'm not sure from the legal practitioner side which comes first. Is it that there's an external body or an external set of laws that are regulating our use and access to such tools? Or is it that we are looking as practitioners at the body of tools available to us, some of which may be AI powered and thus regulated independently, and thinking about how as a profession we are disclosing that use and whether that qualifies as self-regulation? I think it may, but it's an open question in my mind, whether disclosure and regulation and self-regulation all dovetail in the exact same way.
Just picking up on Kieran's point there, I think the difference between ethics and regulation is really important here, because actually there's been a growing consensus over the last few years of what the sort of key ethical principles you might have in relation to AI are. So transparency, fairness and non-discrimination, safety, these are very general principles that almost every framework for AI ethics has. The real question is then how you go from that to a set of rules that companies can follow. And picking up on the Sam Altman quote that Katerina flagged at the start, whether that's even possible given how quickly the technologies are evolving. Obviously in the EU, as we'll come on to see, they've essentially adopted a product safety approach, which sees an AI system like a car or a medical device. Whether that's a practical approach remains to be seen. At the other end of the spectrum, you've really got countries just saying, well, you should just comply with these ethical principles. But is that really too vague to be capable of putting into action? It's going to be interesting to see how these different approaches play out over the next few years.
I mean, just maybe picking up on everything that has been said, it is almost a political and philosophical debate at that level, right? In the sense of, do we want a principle-based approach that is very high level and has some, general principles that will survive over the next couple of years, or do we want to drill down in some of the nitty-grits of principles with the risk of being outdated very quickly? And some of the examples we're going to talk about in more detail during this webinar go one way or another. For instance, the Silicon Valley guidelines on artificial intelligence and international arbitration, which I'm sure we're going to talk about later on in more detail, have a quite high-level principled approach. And some might actually say maybe too high level, and that's some of the criticism that has been leveled. Whereas, for instance, the AUI Act in some instances goes quite into some detail. But on the other hand, this is also meant to be a living document. There is a lot of, well, it's actually foreseen that the document will be revised on a very regular basis, and that takes account of the fact that it is such a, fast evolving sector.
Just
Thank
to
you.
add, yes, sorry,
Alex, go ahead.
Just to add on that, indeed, if we look at the EU Act, it is meant to be a future-proof legislation, and I think all of the efforts that we're seeing right now, be it at the national level, regional, supranational level, like the EU, or within our own arbitration community, they all try to have that understanding that obviously technology evolves and is very fast evolving, and the way we are now crafting rules, regulation, principle, being on a high level ethical principle guidelines, or on a more regulatory stance like the EU, have this sort of future-proof approach, allowing rules to adapt to technological change. And I think, if we go back to the quote that you mentioned, Katerina, saying in 12 months it would be all written wrong. Again, this is probably from somebody coming from a views that the only way is a agency-based approach and a self-regulation by the market, basically. And I think there is, and at least that's what the EU has been trying to find, the right balance between, as Eimar was saying, between innovation, how do you still allow room for innovation while at the same time regulate the risk approach and aspect of AI in building them and using them. I think on Kieran's point, and I think that was very interesting to really put the emphasis between regulation of use and disclosure. But I think one of the key elements is precisely how do you also regulate the disclosure aspect. And then it becomes part of the regulation aspect, especially in international arbitration, and we'll come back to that in a little bit more details, where precisely the question of disclosure is a question that, if not regulated per se, has at least guidelines and very important practical aspect in the development of arbitration as a system of justice, but also very practically on what the duties of all participants are with respect to that particular approach.
Thank you all. And I would like to move on to my next question. Looking at the matter and all of the points you've mentioned through a less generalizing lens, could you share your thoughts on whether you think regulation of AI will play a role in reshaping the legal industry and the way we use AI in the legal sector, and in particular arbitration?
It's a loaded question, Katerina. let me try one small piece of it, and then I'll hand the floor to others to try other aspects. As a practitioner, I think regulation is a really interesting thing because it means our clients would accept its use more readily. So as legal professionals, we have our reputation of being quite risk averse. One, to maintain our clients' trust and confidence, and also as dispute resolution lawyers, also the courts and tribunals that we practice before have their own standards and levels of practice that we must meet and exceed and adhere to. So the first step would be, if our clients trust the available tools, it gives us as practitioners the leeway to explore their use, to recommend their use, to adopt their use, to test, to sandbox, what have you. And the interesting piece there, something I read some time ago, was about, well, what do you do with the cost of this? What if practitioners start using these tools, or if their clients start expecting them to use these tools? Well, these tools are not free. As some of the other speakers on this program will tell you, there's a lot of cost to that innovation, development, and selling those tools. So who bears the cost? Is it you, the law firm? Are you absorbing it? Or is it something that you pass on to your clients as a technology fee, the way that many years ago we would pass on, Westlaw charges? I think a client would laugh at you if you tried to charge them for your Westlaw usage these days, but it used to be quite normal when I started practicing. So the first is, okay, if your clients are accepting the tools, then we can explore more openly and freely. And then, okay, well, how do we train our teams? I work with law students, I teach law students. Professor Scher will say the same thing. These students and these young practitioners need to meet standards and expectations that don't exist yet today, or know how to use technology in a way that we don't know how to use it, because we presume they're better at this than we are, because they're younger and more adept and more recently educated. So there's that piece of it. And then there's, how do you respond to the external bodies that we appear before as practicing lawyers, whether they're courts, tribunals, et cetera. So maybe that's the first step. I mean, if clients accept it, then we can take the next step. But what does that next step look like, I think is quite nuanced.
I could not agree more with what Kieran has just said on both accounts. The first is it will affect the way we practice law and how we train future lawyers tremendously, and it already does. I mean, we at Queen Mary, we have thought about the syllabus on how we teach law and international arbitration for what concerns me, because the knowledge base of I know what the English Arbitration Act says is good, but absolutely not sufficient. It's the skill sets that you need not only to practice arbitration, but also then how to know how to use the available tools. And so, courses on legal tech are, always oversubscribed because everyone wants to do them. On your cost point, I actually have a very neat concrete example of one cost issue in relation to the use of AI that relates actually to document discovery and disclosure, and this was actually before the Canadian court, so it was a court proceeding, it wasn't an international arbitration. But one of the parties was basically claiming back costs that related to lawyers having gone through documents that needed to be checked whether or not they should be disclosed or did fall under a disclosure order. And the court refused that particular cost item on the basis that there was an AI tool that was readily available and free. I mean, obviously it doesn't work if it's not free, but there was apparently a readily available AI tool that was free, or potentially at a minimal cost that was a fraction of the costs that were claimed when human interaction was involved to review those documents. And I think that very, very, for me, pointedly shows your cost point, Kieran.
I wonder if that was, I think it was also in the Canadian jurisdiction where counsel's fees, they were slashed by, I think it was 30%. And it raised this debate of dual generated output, which I thought was really interesting, because I thought, well, what they were basically saying is, and I think it might have been the same case where they're saying, well, you can't obviously charge for the time that you would have taken you, because you essentially just used the tool that has expedited that task. I think that's really interesting. But I think Kieran's point, to actually raise the point that there is a direct nexus between regulation and cost, is an interesting one, because if the expectation is, if the expectation on the cost of AI is that the cost is either passed on, whether it's absorbed, but essentially that there is going to be an elevated cost to the client. The client will want to know, as you both pointed out, that this area that they're working within and these tools that are being used are regulated. And I think that's a very important point. And also talking about the future landscape for, you know, for lawyers. I am helping a university to redesign their legal tech course. And the foundation of it will be that there are loads of moving parts simply because AI is going to be changing how they work, but also AI is also going to be constantly evolving. And so understanding how regulation is going to completely reshape, you know, academia the whole way through. So I think your question on how it's going to change a profession, I think was one of the part of your question. I think it's just going to be fundamental, but it does, and obviously we're talking about regulation today, but it's just really that ensuring that there is public trust and ensuring that that starts, in my view anyway, it starts at academia, and that is really embedded when the students are being taught legal tech, being taught AI. But, and it's just my view, but I feel that that should be an essential part of any teaching on any subject, so that should be sector specific. So if you're being taught arbitration, litigation, as Maxi said, that you should also be taught how to use these tools, what they will look like, and ideally that you should be using them when you're actually at academic level. Anyway, I could go off on a tangent about academia, so let's stop there.
Maybe building on that, I think that, you know, the way regulation of AI will affect the use in the legal sector, and particularly in arbitration, if that's the question. And what you mentioned, Imar, also, we are already seeing the seeds of what's coming. I mean, it's very obvious. And I think, for example, on the professional trainings and certification, and I think probably SAI will have a role to play at some point about that, but you know, we are going to see perhaps mandatory training or certification on the use of AI in various sectors, at least in the administration of justice, being for judges or arbitrator and legal professional broadly. And that's a very concrete impact that regulation might have on the very particular question of accountability and liability. We'll have frameworks that will help define who is accountable for AI-driven decisions. And we're already seeing the seeds of that in the various regulation in place. Maxi touched upon evidence. I mean, the question of admissibility, validity of AI evidence in proceedings before judges or arbitrator, these are rules that are being developed as we speak to really nail the, you know, the new paradigm that AI, or at least Gen AI and LLMs, are bringing now in terms of proceedings. And then I think where there is a really big impact, it's really the link between data privacy and AI, and we're already seeing pieces of legislation really impacting those two aspects, which are very linked together and forming now a huge corpus to which practitioners, arbitrators, lawyers, but pretty much any stakeholders involved in the dispute resolution system are being affected as we speak, and will be affected more and more in the future.
I think there's a bit more to say also about trust, and I think what trust lawyers and their clients can develop in different technologies. So I think there are certain technologies where a degree of trust already exists. So people are willing to trust perhaps e-disclosure technologies to assist with document review, or technologies to assist with research. I think then on the other hand, you have the perhaps more sci-fi type things around AI actually making or contributing to decisions, which in fact is one of the things that's been specifically regulated by the EU AI Act. And there, I think we're probably some way off in most sectors, at least, from people having the trust in the technology required to do that. And one thing that will be interesting to see is whether putting, say, a CE mark on a technology that does that is something that then does encourage people to start thinking about actually using that technology.
Thank you all. I will pick up on something I think all of you have already mentioned, which is the EU AI Act, and it's a highlight probably of today's webinar. So I suggest we move on to the next topic. So in May 2024, the Council of the EU adopted the EU AI Act. According to the European Parliament, its entry into force will take place 20 days after its publication in the official journal of the EU, which is going to happen in June, July 2024, so any day now. So this publication serves as a formal notification of the new law. And the act will be fully applicable 24 months after. This is obviously a landmark piece of legislation, and it's important to take some time to analyze it. Let's probably start with fundamentals. Could you tell us about the regulatory framework and the risk-based approach proposed by the Act? Maybe we could also touch upon penalties for non-compliance with the Act. And we will proceed with some more details after that.
Emma, did you want to start on this, or do you want me to start?
No, so you feel free to go ahead, Maxi.
Happy to. So as Katerina rightly said, it's a final version, but not technically into force yet. It does take a risk based approach in the sense that it tries to categorize different activities according to the likelihood of harm that is assessed to be caused by the use of AI systems. And the regulatory duties then depend on the risk that the EUI Act sort of attributes to a certain activity. And so Alexandra already mentioned earlier that we might see in the future sort of certification of AI knowledge or literacy. There is actually a general duty of AI literacy in the EU AI Act. So this is something that applies to everyone as a regulatory duty, and that basically means that you have to have the skill set and the knowledge to use AI, and that you are aware of the opportunity but also risks that use might imply. Some of the activity is, forbidden outright. I don't think we need to go into that because it's not necessarily relevant for our field of international arbitration. What is most relevant for international arbitration is the so-called category of high risk use of AI systems. And that's where the regulatory duties include, for instance, the fact that you need to use the AI system in accordance with the instructions of the producer. You need to record the logs of the AI system, and you need to ensure there's human oversight of the use of this AI system. So this is, in two words, the general approach regarding different regulatory principles under the EU AI Act. And there are both financial and non-financial penalties that come with potential non-compliance. The $100 billion question, but maybe we're going to get to that, Katerina, in a second, is to what extent it actually does apply to international arbitration. But I'm not going to get into that right now because I think your question was more general to start with.
I think sitting alongside that risk-based approach, and I've seen some debate as to whether this is a risk-based element or not. You've also then got regulation of what are called general purpose AI models. And now this is probably an area targeted chiefly at technology companies who develop very sophisticated AI models. But actually this is a part of the regulation that could bite on legal technology providers as well. If, for example, they are making their own models for a variety of different legal purposes, or if they are taking models that have been developed by, say, a big tech company and then fine-tuning them or modifying them for use in the legal context. But that's really probably more on the legal tech side. It's very unlikely that a law firm or an arbitrator could be caught by those requirements. And really, those are requirements that bite on the technology rather than on particular risk factors. So in a way, they're deemed to fundamentally pose some kind of risk.
Maybe what's interesting to note here, so the general risk approach was the original intention of the EU AI Act when they started to negotiate that many years ago already. Generative AI arrived, and so actually the risk-based approach wasn't really fit for generative AI, and that's where the provision of the general purpose AI came into place. And we're already seeing within the framework of the EU legislative iteration that there has been already during the process massive change to adapt to the already fast evolving technology, to take into account those new innovation thanks to the generative AI. But again, we see the real tension here between getting after the technology while and trying to really grasp a regime that will apply to many different technology, which are very different, and some of them. And I think that also goes into what do we define as an AI, and I think we'll see that in many different framework, being the EU or national legislation or even guidelines, that there is already here at the core of what do we define as an AI, a really important question, because what do you capture is of course essential for legal tech companies who are building AI or Gen AI products, but also from a practitioner perspective of what should I disclose, what is encompassed in those framework at the EU level, at the arbitration disclosure level. And again, we can touch a little bit more precisely on that when we come to this aspect. But there, at the definition level, there are already some issues that are interesting to really be mindful of.
Katerina, I see there is one question in the Q&A which might actually fit in here quite nicely. If you allow me, maybe I'm just going to use that question. It's Peter Fields saying, in the context of arbitration, could be argued to be strange to regulate the use of AI as a tool, but not to regulate the user, i.e. the arbitrator. Isn't it a bit like regulating commercial aircrafts, but not the pilot? And I think that's an excellent question. And so in the context of the EU AI Act, the arbitrators actually, at least in my view, have the potential to fall under the regulation of the EU AI Act. So from a material point of view, what the subject matter of the AI Act covers, it does say in a sort of annex what are the industry sectors that are concerned by the EU AI Act. And it does include alternative dispute resolution. Now, maybe some people might say, well, but that is more negotiation or mediation. But actually, there is a recital in the EU AI Act, which, by the way, is some 400 and whatever pages long and has a lot of recitals. So if you're really bored and want to read all of it, it will take you a while. So one of the recitals actually does say, when we talk about alternative dispute resolution, it is about the outcome of that alternative dispute resolution proceedings to produce legal effects for the parties. So that, to my mind, means that we are talking about arbitration as a binding mechanism of producing legal effects, as opposed to mediation, which is, more bringing the parties into a position where they make a decision. And that's sort of from the material scope of the EU Act. And more to your questions about the personal scope, how is it actually also regulating the arbitrators? And there are various regulated entities, as William has just said. A lot concerns the providers, importers, or manufacturers of these AI systems, but there are also what, under the terminology of the Act, are the deployers, so users of AI system, and that is defined, and I'm going to read it, to you the definition: any natural or legal person, public authority, agency, or other body using an AI system under its authority, except where the AI system is used in the course of personal, non-professional activity. But an arbitrator is, of course, using it for professional activity, and it is a natural person. So arbitrators actually do fall under the EU AI Act, and that is something when I talk to, my tribunal fellow members, no one is really aware of at this stage, and that's why I think webinars and discussions like these are so highly, highly important.
I'm just thinking, I know we're talking about the EU scope at the moment, but I'm just thinking of that, with by analogy with guidelines that have been issued in the UK for the judiciary and for the bar. And they are quite, I mean, they're very brief. It's not 458 pages, but there is that focus on personal accountability, and it's very pragmatic. And I think that it's just very interesting that so it's a bit of a dichotomy in a sense, but and I think that it's going to be very interesting to see how this all kind of plays out as we start to engage and are caught by this legislation at an EU level, and also by the guidance, and obviously just guidelines in the UK and how that looks. So that was just more of a thought than anything else, because I think it's very tricky, isn't it? Because on the one hand, you've got this responsibility and this liability with tech companies to ensure that they're compliant, and there are so many moral and ethical questions around that. But then there's also that professional responsibility, but they're actually intertwined, aren't they, really? Which I think will become increasingly obvious.
Yeah. To maybe give you perhaps the legal perspective of the producer perspective, as the EU AI Act call it. So I think to first of all, there is no doubt really as it stands that within the administration of justice and alternative dispute resolution system, arbitration is included. I went to dig and investigate where that amendment came in, and it was actually brought by French, and they were all very they were all very inclusive of arbitration, and that was what they had in mind. And I think there is no doubt, having heard that really the definition of alternative dispute resolution, as Maxi mentioned, is really on the effect the decision has, and which has legal effect, and of course an arbitral award fall within that definition. We at Jusmundi, as a legal tech company, of course, we do build tools, including generative AI-based tools for practitioners. And this is, of course, something that we're looking very carefully in terms of compliance and in terms of obligation that will fall under the purview of the tools that we're building. And so definitely administration of justice is a high risk system. And what are the obligations that falls under? We have obligation to assess, which are first risk assessment, mitigation system. How do we ensure that we have a high quality data set to minimize the risk, for example, of discriminatory outcomes? Those are very not general, but obligation that we know of. But then it goes into much more details into how do we, for example, make sure that we provide clear and adequate information to deployers? So how, as a tech company, we will ensure that we give the sufficient information to arbitrator using our tools, or to practitioner, or to experts, and the appropriate, human oversight. And concretely, the way the framework works, at least for the providers of high-risk AI system, we before putting it into the market, it needs to undergo a conformity assessment that we are doing, and then that is then validated by the European body regulation, which then implies a sort of registration, and you have a sort of a EU stamp certification on your product, and an authorization to put it on the market. Once that is done, then there are combined obligation between providers like us putting on the market a tool, and deployers, potentially arbitrators and practitioners. For example, there are obligation to report incidents or malfunctioning under the EU AI Act, but generally there is a sort of monitoring system into place, and the obligation are divided between those who build the products and put them on the market and those who are using it. And so again, I don't think, I think Maxi is really spot on in the sense that it does have a bearing on practitioner activities, but we haven't, engaged yet into really the details of that. If I go a step further, and there are exceptions, of course, to the high risk, and I think that's where the devil hides a little bit into details. I don't know if we want to go into that now, but to the high risk exception of building tools into the administration of justice. For example, the tool is to perform a narrow procedural task, then the entire compliance system and overburdened certification process disappear. What are those narrow procedural tasks? And that's where we need more guidelines. And actually, as the EU AI Act stands, it needs approximately 65 guidelines, application guidelines by the European Commission. So we have a lot of time before we see a little bit more clarity on how exactly this will apply. But we already know few concrete applications. So, for example, a narrow procedural task might include, administrative tasks, for example, for managing emails, organizing files, etc., document management, legal research, etc. But again, we need to confirm exactly, for example, that when you use a database like Jusmundi for your own legal research to prepare a case, this does fall into using, or at least using some tools which have a limited impact. And this is again where the again, it's a bit blurry at the moment, and we don't really know what kind of tools are falling under the exception, what kind of tools are not falling under the exception. And a very concrete example, we released at Jusmundi the first arbitration assistant, which allow you to, do research, but also get into analysis and get answers and extract a vast amount of data from the database in a very conversational way. So would that fall into the exception of a narrow procedural task? And that would depend on what you ask the assistant. If you ask the assistant to make a procedural timeline of a case or of a various set of documents, is that a procedural narrow task that doesn't fall within the burden? And so again, we're going to see here various regulation applying to different different use case depending on the product that you are having. And right now in arbitration, we already have many use of AI for different tasks. And I think this is really where, at least on our side, what we're doing, we're cooperating with the European Commission to try to have at least a very concrete set of standards that are applicable in a uniform way to be able to tackle those issues, because there will be a lot of impact into our practice of international arbitration.
Thank you all. It's amazing. Haven't heard from you. I have even more questions now, but I'll stick to the plan. I would like to refer to the question that Maxi raised, but didn't elaborate on because she knew would mention it later. Could you express your opinions on how the Act will affect international arbitration? Maybe we could also talk here about territorial application of the Act. Some aspects here might be important for some matters practitioners in international arbitration have to take into account. So maybe you could let us know what important matters you think we should keep in mind.
Yeah, and it's a fair question because there are a lot of attendees on this call who are not based in the European Union. So you might think, why are we talking about this, European Union Act? I couldn't care less about this. I'm based in Asia or in Africa or God knows where. That's where the question of the territorial application of the Act comes into play. At least when it comes for the deployers, i.e. users of AI systems. So I'm not talking about the Jusmundis and those who are producing or manufacturing AI systems, but the users, for instance, arbitrators. There is a double criteria for the territorial application. It's either the deployer must have its establishment within the European Union, or if the establishment is without outside the European Union, then it depends on whether the output produced by the AI system is used in the European Union. And I'm afraid, Katerina, I'm going to add to your list of questions, because what does that mean? I mean, if you think about the first of those two prongs, a place of establishment is within the European Union. You could look at the individual arbitrator and say, okay, if she has a domicile, professional domicile within the European Union, then that's fine. But what do we do with a three-member tribunal? If you look at the individual arbitrator, then that means that you have different regulations applying to different arbitrators on the same panel. That might be what is intended, but it might also be that, you know, it is one award and one decision-making process, and that really the regulation should apply in the same way to the three members of the tribunal. And then the place of establishment that one would look at is most likely the seat of the arbitral tribunal. So where if the seat is in the EU, then the EU AI Act applies. But then you have the second prong. So even if the seat is outside the European Union, or even if the individual arbitrator is based outside the European Union, you could still fall within the territorial scope of the AI Act if the output produced is used in the European Union. Now, what on earth does that mean in the context of international arbitration? So the output produced, probably the award. So if the award is used in the European Union, does that mean if one of the parties is affected by the award, and if one of the parties therefore is based in the European Union and one party only, then the European AI Act applies? Or could it even be further that if one party, even with a seat outside the European establishment, outside the European, has assets in the European Union, and an award is enforced against those assets, then it might still be said that the output produced by the AI system is used in the European Union. So you can see there is a potential risk, chance, depending on how you look at it, of a very broad extraterritorial application of the EU AI Act. And that's why it is so important for all of us, whether you're based in South Africa and Brazil or in Singapore, to think about these things very carefully.
And I think that answers one of the questions, which is in the Q&A box, which comes from Svetlana, who is from South Africa and is the Secretary General from the South African AFSA institution, which raised a question, which is, how will the EU AI Act affect compliance requirements for arbitral institutions that are building tools based on AI within their case management system, for example? And I think that's a very good question. And if we follow Max's reasoning, I mean, depending on what the results of the AI tools use, I mean, if you use, for example, a AI system to help drafting an awards, which then generate effects within the European Union territory, that would trump. I mean, if we look at the territorial scope, that would trump the application and the regulation of the EU AI Act. And I think it's a very these are very, very good questions. And we see, as a matter of policy, just like the GDPR, the European Union intention is to build the global standards for AI. And so there is little doubt that the intention of the effect on the territorial scope is as wide as possible and as applicable as possible. So we are already seeing a lot of discussion between the huge providers of LLM like OpenAI and Microsoft and so on, having already issues of getting into compliance with the EU AI Act prior to its application, to be able to continue to develop their products on the European market.
I'm sorry that this is a question, not an answer or a comment, really. With, you know, historically EU law there's been enough of scope for creative arguments, essentially. And I just touching on what you both said, do you think that is, do you think that obviously because it's very detailed, it's also very comprehensive, but completely open to interpretation on certain points? And do you think that we're just going to be in a stage for some time before those kind of questions are answered? Is that really where we are, do you think?
Well, I personally think that we that we have a chance to actually voice some concern and have a bearing on those. Again, the text will be will need more than 65 application guidelines, and there are a consultation around from the various stakeholders. And so the more we raise those issues, the more we can also influence on the outcome of those issues. And it's not for now set in stone. And I think there is at least a willingness to have and hear the various participants from the producer to the deployers. And if we agree, as Maxi suggests, that international arbitration community is definitely concerned by that, then there should be some type of action. And if we remember, for example, what happened for the Brussels 1 regulation when it was reformed, the entire arbitration community raised concern about the inclusion of the arbitration within that regulation, etc., and had an impact on the solution that was ultimately adopting during the revision process of the Brussels 1 regulation. So I think we can do something if that was the question.
Which is why this is so important, these kind of sessions, obviously.
But no, it probably is going to be quite a while before, for example, the question of how expansively the output of an AI system will be interpreted is answered. It might be quite some time, because potentially that could be staggeringly broad.
Thank you all. I'm just being conscious of time, so I think we should move on to the next session and talk more about other sources. And so from international coverage, I suggest we move to a local one and briefly discuss national approaches to regulation of AI. According to the Global AI Law and Policy Tracker released a couple of months ago, there are a number of countries that have introduced policies, bills, and in some cases laws on AI, including Australia, Argentina, China, Peru, Saudi Arabia, the US and the UK, of course, with numerous national authorities involved. I like to ask questions with multiple layers, as you've probably noticed. So my next question is going to be threefold. Could you tell us what are the tendencies and developments in some jurisdictions? Whether, in your opinion, the response is equal to the scale of the matter we're discussing today, and what we should expect going forward.
I'm happy to pick those questions up for the UK. And I think the slightly flippant answer to the sort of core question is what the approach is in the UK is there's not much of an approach right now. The UK had a white paper last year, followed by some guidance to existing regulators this year, but there's nothing on a statutory footing. And apart from a private members bill, which has now fallen away, there is no plan for anything to be on a statutory footing. To the extent there was a sort of a very broad brush principles-based approach until recently, that has now been thrown very much up in the air by the plan for a general election. And so really until a new government is elected, it's going to be pretty uncertain where we're going. The mood music previously has been that it will be more principles-based and perhaps less onerous than the EU approach. But if we have a different government next, you might see a greater degree of convergence here. So in answer to the question, is it equal to the scale? Possibly not. It probably hasn't been as much of a priority as one might hope for the current government. And in answer to the question, what should we expect? The answer is probably it's really very much up in the air at the moment.
So if we look a little bit at the various legislation, so of course we touch upon a little bit on the EU AI Act. What does it imply for producers, developers, and I think other interesting examples are coming from Asia, where they are very innovation driven. And I can take a couple of examples. One is China and one is Singapore, where they are already really at the forefront of building some regulation, and it has been done in step. China started in 2021 and released in 2022 an opinion on regulating and strengthening the application of AI precisely in the judicial field. And the judicial and arbitral field are really one of the key points in the AI strategy of those countries. China is really embracing AI and really supporting the innovation development at that front, supporting institution also. And I don't know if you've seen, but CTAC released the new arbitration rules, which are very much tech oriented and really push forwards the use of technology in arbitral proceedings. We've had very recently during the ICA Congress, a demonstration by one of the Chinese institutions from the Shenzhen Center, if I'm not mistaken, of generative AI included within the institution to allow for a first draft for arbitrators. So and this is supported by obviously government legislation and initiatives. And right now we don't have a comprehensive set of regulation, but you have a lot of various initiatives aimed at boosting innovation and embracing, or at least have a pie of that market. Singapore is more going towards building frameworks, and within those framework, and so they have a model of AI governance, and they try to provide sort of some detailed guidance to the private sector to address the key ethical and governance issue. And so we're back to where we started with those two approaches, either a sort of a certain auto-regulation by the sector with some kind of model and governance framework by governments, or we have on the opposite side regulation. And if we look, for example, at the US, right now, there is no comprehensive federal legislation at the moment, but there are a lot of talk about it. And we know that there are a lot of talk between the EU and the US at the moment to try to align those types of regulation on the various framework that there exists right now.
Thank you, William and Alex. Before we move on to the next and final section, I have an additional question. And I was thinking maybe I should leave it for a Q&A if we don't have enough questions, but maybe this is the right moment to ask it. Just a general, more of an existential question from me, and I came up with it while getting ready for today. So I was thinking the origin of artificial intelligence dates back to 1950s, and from the research I've done on different legislative initiatives on AI around the world, it is noticeable that most of them were started being developed or introduced after 2015. And while we all started using or relying on AI a long time ago, in many cases without even realizing it. Some examples of this include face recognition technologies, like in the airports, or Google search, or Amazon recommendations, or even bank transaction fraud alerts. All these are AI. Why do you think it has been taking so long to take a firm stand in relation to the importance of AI regulation? And do you think we have lost momentum and now it's going to be even harder to regulate?
I think it's a really interesting question. I think I may be wrong, but I do think that because we have AI, as you said, has been around for a very long time, and the use of tools like e-discovery, predictive coding, we've all kind of been familiar with those, but we just kind of accept that they're there, and we probably don't really think about them very much. But this is kind of dovetailed with I think the kind of this great catalysis of ChatGPT. And because generative AI tools are suddenly out there in the public domain, and they're in our psyche, and obviously our professional behavior reflects how we behave personally a lot of the time. And things have advanced very, very quickly. I mean, you referred there to manipulated images or image generation. We've got that kind of fear factor, I think, has really started to build in the past 12 months. And interestingly, I was speaking at a session where I was with someone who's very much more tech than I am, but they were talking about this kind of almost an arms race for generative AI, particularly on the image generation and video generation side of things. So, you know, for example, in order to ensure that a video or an image is genuine, there are, you know, watermarks, or there are tools to demonstrate that there is blood flow in, you know, in the skin, you know, whether it's heat generated or otherwise. But equally, then there are other tools being developed that can emulate those. So it's a kind of this kind of acceleration then lag, acceleration and lag. And I think personally, I've used ChatGPT for various things, never obviously anything confidential, but the evolution of that tool since I started using it has been, you know, almost mind-blowing. You know, and I think that we're all caught up in this, and therefore we are now actually realizing that this is going to change far more quickly than we thought. In terms of why the acceleration has happened on a technical level, given that we've had these AI tools for a very long time, I can't speak to the technical side, but you know, this psychology behind our behavior, which is then driving uptake of these tools, which is then, of course, pushing particularly people in the legal sector, including obviously in arbitration. I think it's really driven by that. I mean, it's obviously not as simplistic as that, but yeah, I think there's a lot of, it's been driven a lot by fear, actually, I think, and also some excitement by these tools as well.
Yeah, I think it's absolutely right that ChatGPT caused a massive step change in the interest in AI regulation. So I remember when I very first started to look at AI ethics and so on, which I think was in about 2019, the OECD had just released some principles for AI. And, you know, it's very general, very high level, and it's focused on these particular, it was focused on these particular types of case studies of where AI had gone wrong. So where you had people being offered different credit card limits for apparently discriminatory reasons and so on. And I think that sort of interest in very particular issues is what informed the earliest drafts of the AI Act, where it's very focused on certain things. And then it's with ChatGPT that I think there's been a realization that there's this massive general thing that's going to apply to lots of sectors and so on. Because while, for example, certain AI systems were being used in websites and so on 10 years ago, I think the prospect that, for example, you might have an AI system that could competently write an arbitration award is something that has happened a lot more recently than that.
Thank you. This is indeed a very interesting topic. I suggest we move to the next and final one about other types of regulation available. So some dispute resolution institutions have also published relevant guidelines, rules, and even model clauses on AI in arbitration. The Silicon Valley Arbitration Mediation Center being one of them. In April 2024, Center published its guidelines on the use of AI in arbitration. Can we talk about the guidelines as a whole and what matters does it express the center's perspective on? Although I think it's important to note that the guideline was published for public consultation too at the time of its development. And then I suggest we move to what the guidelines have to say in relation to the use of AI by parties representatives. And I'm particularly interested in your views and on the provisions relating to disclosure and confidentiality. This is something we mentioned at the beginning of the webinar.
Thanks, Katerina. I'm happy to try to give a brief overview for those who do not yet know what are the Silicon Valley Arbitration and Mediation Center guidelines on the use of AI in arbitration. So as you mentioned, it was open for consultation in last August and until February. It was put forward by a drafting committee and then a review committee with impressive figures of the arbitration community with a certain Professor Maxi Scherer, who was included in that review committee, helped to really review the consultation from the stakeholders. And we at Jus Mundi, we also reply to the draft to also put forward our views on the guidelines. What are they? So they are a principle-based framework on the use of AI in arbitration, to be used in domestic or international arbitration proceedings, and to really be a point of reference for tribunals and parties representative alike on the use of AI. So we have three chapters, let's put it that way. Or you have preliminary provision really on the scope and the application of the principle, and then you have really the body of the guideline, which is one chapter on guidelines that applies generally to all participants, one second part which are guidelines addressing the specific use of AI by party and counsel, party representatives, and a third aspect which are addressing consideration specifically to the use of AI by arbitrators. Now, on the applicability, the guidelines apply if parties consented to it and provide that they do not derogate from any legal obligation, being ethical rules or arbitral rules from an institution under which the arbitration is administered. The definition of AI, and so it's still in the preliminary provision, which I quote, the terms AI refers to computer systems that perform tasks commonly associated with human cognition, such as understanding natural language, recognizing complex semantic patterns, and generating human-like output. So in the commentary of the guidelines, this definition is said to be adopted to be broad enough to encompass existing and foreseeable types of AI. So again, they're trying to have a sort of a future-proof type of guideline, just as any type of regulation is now trying to have. But also they were trying for that definition not to be broad enough to encompass every type of computer automation tool. It's still, in my views, a little bit too broad, and and I think here I would recommend definitely in using those guidelines to carefully consider by the participants of what we're talking about, what are included or not. But these are details. If we look at the guidelines to all the participants, the first one is really understanding the use, and to quote again Maxi, it's the duty of literacy, as you mentioned earlier. Really understanding the use, the limitation, and the risk of any AI application. The second important point in the guidelines for all participants is really relating to confidentiality. This is a general obligation that we find in all the in all the judicial guidance that are out there that we've seen, especially the UK one is pretty well drafted on that aspect. I thought, which really encouraged the parties to be mindful of their own obligation of confidentiality towards their party, but generally in the arbitration. And the third one, which is really about disclosure, states that disclosure is not necessary as a general matter. So this is a starting point of the disclosure obligation within the guidelines, and that decision regarding disclosure should be taken on a case-by-case basis, taking into account various factors which are developed in the commentaries of the guidelines at some point. There are some guidance into what should be disclosed and what should not be disclosed, but at least some elements of consideration. Name of a version of the tool used, the description of how the tool was used, the complete prompts or the associated output, etc. When one turned to the second part, which are really guidelines for parties and parties representative, we have what is called a duty of competence or diligence. And again, this recall the fact that as a practitioner, you should really observe any applicable ethical rules or professional standards. And that you obviously have an obligation to review the output of any AI tools used to prepare the submission, or to verify at least that it's accurate from a factual or legal standpoint. So that's what the guidelines say, but it doesn't really expressly say what's the consequences of non-compliance of its duty. But you can find some elements of that within the commentary of the guidelines, but not in the guidelines itself. And so if you turn to the commentary, you find a little bit more concrete application of what would be the consequences of a non-compliance of this duty. And for example, the tribunal will take into account, for example, when deciding on how to address submission containing AI-induced errors or inaccuracy, the power, for example, to strike the submission, order correction, disregard the submission, attach a lower credibility. These are all sanctions which are, I think, within the powers of arbitrators generally, but which are recalled in the commentary of the guidelines for more precision. You then have some guidelines with respect to the integrity of the proceeding of the evidence. And the rationale of these guidelines is really, particularly when we talk about generative AI and deepfakes, it's really to raise awareness on the fact that with Gen AI, you have an increased risk of manipulating evidence, etc. Sorry about that. And so perhaps again, what the guideline does not say here is what the tribunal should be doing if the tribunal determines that a party has violated that guidelines. But again, here we find some guidance in the commentary of the guidelines. I'll just wrap up here with the last part, which is really for arbitrators. And the most important guideline probably is about the non-delegation of decision-making responsibilities by an arbitrator. So once we've said that, what does it mean really to not delegate, I think, the decision-making power? And I think we have two arbitrators here, and that might be interesting to hear their views on how this guideline could be used concretely. But I think perhaps on my side, what would be interesting, what would have been interesting perhaps is to have a little bit more concrete example of when do we delegate or not delegate decision-making power. I'll leave it here for the moment, but I think we can engage in some conversation about that particular aspect.
I'm happy to pick up on that, and it sort of draws a nice, line back to the introductory session that Katerina put to us. The Silicon Valley guidelines are very high level, so the fact that an arbitrator shouldn't delegate its decision-making powers is that high-level principled approach, and equally that as a general matter you shouldn't disclose as a participant the use of AI, but it depends on the circumstances, is equally quite high level. And the difficulty will really be to apply this to specific circumstances. And on the disclosure side, the real difficulty for me is to make sure that you don't over include by using a broad definition of AI. Because, I mean, if I, as a participant in an arbitration, or any counsel as a participant in an arbitration, needs to disclose the use of AI, and AI is defined very broadly, I mean, where does this stop? I mean, any Google search and any email filter uses some form of machine learning. And so one needs to be very careful that you don't over regulate and you don't broaden that disclosure too much. So I think it's right that the Silicon Valley says, as a matter of principle, there is no such general disclosure. But what are actually the circumstances where you need to disclose? And this is, I think, where we need to get, take it a bit further in terms of some of the decisions and discussions that we have. One could, have a sort of IBA red, yellow, green list type of approach, etc. Now, on the second point, which is the delegation of powers, there is a parallel and what could use to actually human assistance to arbitrators. So any task that a tribunal secretary could do And of course, you need to tell the parties what that is. Similar tasks could also be done by AI systems, but that's again only a starting point for a discussion and reflection that I think needs to go much more into detail than what we have so far.
I think the interesting challenge here may be in how these guidelines are put to use. So just to contrast it from the mandatory regulation that we've been discussing in terms of the EU AI Act and its quite potentially broad extraterritorial and long-lasting impacts, the Silicon Valley guidelines are not law, they're kind of soft law up to the discretion of the parties institutions, council, what have you, to implement voluntarily, to adopt and adapt for their use. And I think that's a risky proposition. But there's obviously been great success with other similar guidelines, such as some of the IBA guidelines on taking of evidence, IBA guidelines on conflicts of interest, things like that. But there are others that have had less traction so far. And I recall a few years ago when the ICA was putting together their guidelines on civility in international arbitration practice. So different topic, but kind of similar idea that, we have an international community and an international practice, and let's find some standard setting ideas and put them to use and put them out there for adoption. I spoke with some of the leaders of that drafting committee, and they had expressed to me their aspiration that, well, maybe it'll be adopted by arbitral institutions. And if arbitral institutions adopt them as part of their rules or part of their practice notes, then it'll get broader use by counsel, by parties, by individual arbitrations. And I think with the Silicon Valley guidelines, it's sort of a similar trajectory, that I think the primary target audience, and at least in my mind, having read them and feeling that they're quite broad, are arbitral institutions and possibly individual tribunals. And should they be adopted in that sense as part of procedural orders, terms of reference, et cetera, then possibly they trickle down to parties and counsel and the impacts on possibly witnesses, expert witness, and so on and so forth, in terms of how they interact with tribunals and arbitral proceedings. I find them a little personally a little vague, but perhaps that's because I have not yet put them to use and interacted with them and see how not only future-proof, but how realistic they are to actually put meat onto the bones. But I'm glad that they exist as a standard setting, especially as this conversation has highlighted that there are many of us who are looking for guidance and instruction, and to have something there to start with, I think is a really, optimistic position to be in. Although I do personally find the definition, as you all described it already, as Alexander in particular, the definition of artificial intelligence is a little bit probably too broad for me. It's very future-proof, and I know in the draft it explained quite in detail why that particular definition was adopted. My concern, and I've seen this already in practice, is that the Silicon Valley guidelines definition of artificial intelligence differs from other people's definitions. So there's a lot of misunderstanding of what that definition may be. And there's a presumption it's only for Gen AI, or it's only for this, or it's only for that, all of which are incorrect, because the guidelines themselves set out very clearly what their definition is, but it's different because a future-proof definition. And I think that is an example of how hard they may be put into use.
Thank you all. I think we are closer to the end of the webinar, so it's time for us to move on to Q&A, and we have a couple of interesting questions here. But other than that, I think we've had a very interesting discussion. We've discussed so many complex matters, and obviously the more we talk, the more questions there are. As I mentioned before, this topic is like a kaleidoscope of things. But let's refer to the questions posed by the audience. I'm looking at a couple of them, and the biggest one, I will mention this one first because it makes a beautiful reference to what we've discussed before. The question is posed by Peter Fields, and he says, it is important to distinguish between old AI for example, Satnar face recognition and generative AI. The technologies of large language models, machine learning, and natural language processing are completely different. Sam Altman, founder of OpenAI, observed recently that anyone who bases their view on the use of regulation of AI on the current capacity will be wrong. He predicts that the growth rate means the functionality and capacity will be 100 or 1,000 more in just a few years. Do the panel think there is a risk that overregulation and guidelines set now could inhibit the potential use and development of AI? He also mentioned that he's speaking as a user of AI for 18 months and an active user of the professional version of GPT-4, Gemini Advanced, and Copilot. Would anyone?
I'm happy to take this up.
Sorry, go ahead.
Oh, go on, sorry.
No, you go.
I was going to say, if the question is there a risk? I think there certainly is a risk. I mean, we've already seen some of the larger tech companies rolling out new models more slowly in jurisdictions that they see as being more regulated. So, for example, delaying release in the EU on the basis of regulation. I think that's probably likely to accelerate with the EU AI Act. So you might see delays in availability of technology in the EU. And there's a risk that that would happen in other jurisdictions that adopt harsher requirements for the most sophisticated models. That said, the actual regulation that's generally being proposed for what you might call frontier models, the most sophisticated models, both in the EU and the US, is mainly focused on documentation, testing, making sure the models are secure and don't pose any obvious systemic risks, and whether those kinds of requirements could really inhibit innovation is I think much more uncertain.
Yeah, I think it, not to sound like a lawyer, but I just think it really depends, because you've got, on the one hand, as well as alluded to, you have companies that are kind of pulling back in certain jurisdictions, and you kind of get the sense that some are kind of pushing the race ahead and others are holding back, thinking, well, I want to see how this plays out, essentially. But I do think, though, that also important to kind of highlight the disparity between AI tools that are used in the public domain and also the AI tools that are used in the legal sector, because I think that they're going to develop, and there's just going to be a kind of the way they take their own paths, in a sense, because obviously the legal tech industry has been completely shaped to work around lawyers, to work around litigation, arbitration, versus those that are in the public domain and have a completely different demographic, that completely different goals and aims. And obviously the regulation that we're looking at today encompasses the whole world of AI. But I just think, in terms of the innovation side of things, I think the innovation side of things will automatically be slightly curtailed in the legal profession anyway, because we need to have all of the data, everything in very set parameters and held within four walls, and ensuring that confidentiality and security are kind of paramount. And it just comes back to that theme of trust as well. And I think, for me, the danger outside of the profession is that as humans, we tend to equate, anything that's done at speed and it seems plausible, we equate that as being the truth. And I think that can be quite dangerous, whereas as lawyers, obviously, we're trained in a certain way, and there is underpinning of cynicism, I think, that may actually pull back innovation in legal. Who knows?
Thank you. There is another question. It's not related to regulation, but I think it's an interesting one. As the Dine Basiri, I'm sorry if I'm pronouncing it wrong, is asking, in what ways can AI be used not only for resolving disputes, but also for preventing them or promoting early prevention?
I think that's an excellent question. And really, I mean, for instance, some of the outcome prediction tools have been a lot of times the discussion when it comes of outcome prediction is, does this replace decision making by arbitrators? But I think much more realistically, what it will do is it will actually help in the phase before you go full-blown arbitration to assess whether or not your case is really worth the while. It will also help potentially making funding decisions for third-party funders. And all of that eventually is actually dispute prevention in a way, because they will end up not being arbitrated if the AI tool predicts that the likelihood of chances of winning are very low. So I think that's one possible way of how AI could be used of preventing disputes. Now, early intervention is actually within so once the arbitration has already started, and here AI tools may again be helpful in putting to the forefront of everyone's mind, parties and arbitrators, the patterns that are in the submission, so that there are certain points that really are maybe keeping points, so that once you determine those in advance, you can maybe get to a quicker analysis. Now, all of that, of course, should be also doable if you very carefully read the submissions from day one. But that means that everyone needs to pay for the arbitral tribunal to do that job from day one. And very often, if it's, for instance, an hourly base fee, that comes very costly. So AI might actually help to identify these gateway issues without having a human having to read hundreds and hundreds of pages of submissions in an ideal world. Whether that is actually doable is a different question.
Thank you. And unless anyone would like to raise anything else, I think it's time to wrap up. Although obviously the topic is so interesting, I could go on and on and on about it. But I would like to thank our speakers for joining us, for sharing their experience and thoughts. And I hope everyone who joined in the audience found it enlightening and interesting and thought-provoking. I certainly have, and that's the beauty of it, isn't it? Thank you so much, everyone, for joining. And I think this is it. This is the end of our discussion for today. I just have a couple of closing remarks. For all updates and information on future webinars, please visit our website. If you'd like to view this recording, it will be available to you by next week, and you will receive an email instructions how to access it. Just as a brief reminder, this is the second session of the 6-part series. Our Let's Discuss Networking event on the same topic will take place on 4th of July, and we hope to see you there. Thank you all for joining, and have a wonderful rest of the day.
Thank
Bye.
you.
Thank you, Katerina.
Thanks, Katerina.